Good morning, everybody. I'm Michael Halsey, and I'm here to talk to you about fixed-term contracts and redundancies. And my colleague Bob is also with us, and he will cover a particular case relevant to the HE sector. So uh, if we move on to the next slide, actually some housekeeping first. It'd be great if we could have your questions as we go along. And then at the end, Bob and I'll look through those and try and provide some answers. So stick them in the Q&A, as Tamar said, and then we can look at them at the end and run through them. And it's really great to hear what questions you have, so please keep them coming. We'll do our best to answer them. So looking at fixed-term workers, fixed-term employees, and redundancy first. So looking at first the basic principles. So what is a fixed term contract? Well, a contract of employment that will terminate on expiry of a fixed term, the completion of a particular task, or the occurrence or non-occurrence of a particular event. So some obvious examples are contracts that are stated to end on a specific date or cover maternity or sickness leave, and are stated to end when the substantive post holder returns. Contracts that are related to specific funding streams, and obviously that's very relevant to HE, or contract is due to expire on completion of a particular project, which is also relevant in the HE sector. Fixed terms will often have obviously have an end date, but usually as well they'll have provisions for termination during the term of the contract on notice. So why are they used in HE? And I've slightly mentioned this already. Obviously, it's to create some certainty and flexibility in particular areas, particularly research, where it's linked to a particular project or funding stream. And I think also from experience in relation to maternity cover, sabbatical cover, and long-term sick cover. So looking at dismissal there, so leaving aside the fixed-term employee regulations, which I'll come on to in a bit, fixed-term employees enjoy the same statutory and common law protections as any other employees, including the right not to be unfairly dismissed, wrongfully dismissed, or dismissed for any discriminatory reason. The expiry of a fixed term amounts to a dismissal. So if the employee has more than 2 years service at the point of which the fixed term expires, then the employer must be able to show a potentially fair reason for the dismissal and that a fair process was followed, just as you would for any other employee. I've mentioned 2 years there. Obviously, we all need to note that the qualifying period may well change under the Employment Bill in 2026. And as far as we're aware, there's no special provision for fixed-term employees in relation to that. I'll mention that a bit at the end when we look at a short case study. So if a fixed-term employee, just jumped on a slide there, still on the question of dismissal, if a fixed-term employee is terminated partway through their fixed term, they need to be paid their notice, obviously, unless they've committed an act of gross misconduct. If there's no notice period within the fixed term, then on the face of it, the employer may be liable to pay out salary for the remaining or unexpired period of the term. So obviously, it's important to consider at the outset whether you want a notice provision. So popping on to the next slide. Looking at the fixed term employee regulations 2002 and just running through some of the key concepts. So the idea of the regulations was to provide parity of treatment between fixed term employees and comparable permanent employees. And they state that the fixed term employees are entitled not to be treated less favourably than comparable permanent employees by reason of their fixed term status, unless the employer can objectively justify the difference in treatment. So who is covered Well, employees are covered rather than other types of worker. And there are some specific exclusions in the regulations around apprentices, agency workers, employees on a government training or work experience scheme, and students on work experience for up to a year as part of their higher education course. So what amounts to a comparable permanent employee? Well, they have to be a current employee. So fixed term worker can't compare themselves to someone who's left or not joined yet. Not on a fixed term, obviously, needs to be a permanent employee. Employed by the same employer and in the same workplace. Although in relation to workplace, if there's no comparator in that workplace, the employer may look to other workplaces, but not to associated employers. There must be the same employer. And the comparable employee must be carrying out the same or broadly similar work, having regard to their skills and qualification. So looking at comparable work there, the temptation is for an employer is always to point to differences between a fixed term worker's job and the job of the comparable permanent employee they may have named in a tribunal claim. But the correct way to look at it from the tribunal's perspective is that to give particular weight to the similarities between the jobs rather than the differences. So if a large proportion of the job is the same, the question really is whether the differences are of such importance as to prevent the overall work being seen as the same or broadly similar. So out of that, it's clear that there's no hypothetical comparators. They must be a real person. So it's unlike the discrimination legislation. Looking at less favourable treatment, this can be in relation to the terms of an employee's contract, for example, exclusion from certain benefits. And the benefits don't need to be contractual in nature there. It also relates to any other detriment, for example, dismissal, bullying, or harassment. And it might also relate to an employer's failure to carry out a particular action. For example, not carrying out appraisals, for example, for fixed-term employees, when you would for a comparable permanent employee. And the regulations in relation to less favourable treatment make some specific mentions of service qualification for particular benefits. So that's going to amount to less favourable treatment unless it can be objectively justified. The opportunity to receive training and the opportunity to secure a permanent position in the workplace. However, it's important to note that non-renewal of a fixed-term contract does not amount to less favourable treatment. The tribunal decided that some time ago because it concluded that if it was, then entering into the fixed term itself would be less favourable treatment. So it's the non-renewal is not less favourable treatment of itself. So looking at the reason for the treatment must be on the ground that the employee is fixed term. Now that sounds very straightforward, but there has been a little bit of uncertainty around this following some decisions under the part-time worker regulations, which employ a similar test to the fixed-term employee regulations. So the reason for the treatment, traditionally, the English courts have looked at sort of the effective and predominant cause of the treatment, meaning that fixed term or part-time status need not be the only cause of the less favourable treatment. However, there's some conflicting case law came up in the Scottish courts that a worker's part-time status, in that case, must be the sole reason for any less favourable treatment. And over the summer, the Employment Appeal Tribunal in England felt bound to follow the Scottish version of this because the Scottish court was a higher court. So the EAT said it felt bound to follow the sole reason test, even though it expressed some concerns about that test. So the upshot of that is, in theory, it's much more difficult now, or it's more difficult, shall I say, for someone to show that the reason for the treatment was their fixed term status, because it has to be the sole reason, which might be difficult evidentially. But there is some conflicting case law here, and there remains some uncertainty, I think, on the point, particularly given the EAT's reservations on the case law. And we'll have to wait and see as to whether the case reported over the summer will go to the Court of Appeal or not. Next point on the slide there is the right to request statement of reasons. So fixed-term employees can request a written statement of the reasons for any less favourable treatment, and the employer must respond in 21 days. And in cases where fixed-term contract is not renewed, employees can ask for a statement for the reasons for dismissal as well. Going on to objective justification, you may well be familiar with this from discrimination legislation as well. Employers are permitted to treat fixed-term employees less favourably than their comparable permanent employee if they can show that the treatment is objectively justified. And broadly, this means that an employer must show there is a good business reason for the treatment and its employers acted proportionately. Where the alleged less favourable treatment relates to a term of an employee's contract, justification can be argued in two ways, either on a term-by-term basis, showing justification, or by showing that the value of the fixed-term employee's package is at least equal to the value of the permanent comparator employee's package. So a sort of holistic view as well as a term-by-term view. Moving on to the next slide. Still looking at some key concepts. The use of successive fixed terms. So it's to prevent abuse arising from the use of successive fixed terms. Any employee who's been continuously employed for 4 years or more under successive fixed term contracts is automatically deemed to be a permanent employee, unless, and this is important, the continued use of fixed term contracts can be objectively justified. So this will always be looked at on a case-by-case basis. And I think it's quite risky to hold any one case up and say that this shows that the use of successive fixed-term contracts in a particular job environment will fall within the scope of the 4-year rule. Because in each case, the tribunals look at the facts of the particular case and take a view on that. And clearly there's a big difference in a situation, say, with researchers, where a researcher may have been simply, their contracts fixed term may have been simply renewed without any thought at all over a long period of time. That would obviously potentially be much riskier for that university, that that person might be deemed to be permanent. Contrast that with a situation where the same researcher, the use of their fixed terms may have been carefully considered and reviewed at the expiry of each fixed term. And there may have been very good reasons as to why a further fixed term was included. In that situation, there have been cases where universities have shown that the use of successive fixed terms was justified. Looking at permanent vacancies there, as I think I mentioned briefly earlier, fixed-term employees should be given the same access to job vacancies as permanent employees to avoid any allegation of less favourable treatment. And looking at service-related conditions, any service-related conditions, such as pay scales or access to certain benefits, must be the same for fixed-term employees and permanent employees, except where any difference can be objectively justified, and there might be reasons around cost or administrative burden. So going on to the next slide, looking at redundancy and fixed-term employees, the first point there is less favourable treatment. So it's likely to be unlawful to select for redundancy simply on the basis of fixed-term status, unless the selection, of course, can be objectively justified. That may be pretty difficult if you're selecting on the basis of fixed-term status alone. Excluding fixed-term employees from redundancy pools or considering them or not considering them for suitable alternative employment is also likely to be less favourable treatment, I think, unless, again, that can be justified, and we'd have to look at the case for that, but it might be difficult. So, as I've said, it's difficult to think of situations when selecting for redundancy on the basis of fixed term status would be lawful. The usual approach would be to have selection criteria that apply equally to fixed term and permanent employees, even if those criteria, as a matter of impact more heavily potentially on fixed term employees. As long as they're the same, that's the first important point. And just to note that selecting an employee for redundancy will be automatically unfair if the employee was selected because they've asserted rights under the fixed term regulations. And this is really a provision to prevent abuse by employers. And there's no service criteria for that. So that's a day one right, as other automatic unfair dismissal rights are. But as I say, it only applies where the individual is selected for redundancy because they've asserted rights in various ways under the regulations. Objective justification in the context of redundancy, it can be objectively justified to use selection criteria that are likely to impact fixed term employees more than permanent employees, as long as the same criteria is applied to all. I mentioned that briefly above as well. In relation to collective consultation, this is engaged where employers are proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. And fixed term employees will not count towards the numbers where the proposed dismissal will take effect on expiry of the fixed term. However, if the proposed dismissal will take effect before the expiry of the fixed term, they will be counted. Finally, a quick comment about enhanced redundancy schemes. Employers are unlikely to be able to justify exclusion from enhanced redundancy pay. Looking at a few different commentaries before the talk, it might be possible to do this, but only if the employer can demonstrate that it usually recruits fixed-term employees on a single contract for specific tasks, and there's no expectation of renewal on either party's behalf. I suspect that there would need to be a lot of evidence to support this type of approach and to explain why there may be some exceptions in some cases. So it looks like a pretty high hurdle, and I think the general rule is that it'd be difficult to exclude from enhanced redundancy pay. So moving on to the next slide, it's a quick case study here. So a researcher is employed on a fixed term contract. The end of their fixed term is approaching, and there'll be no further work when it comes to an end. What are the key issues to think about? Well, obviously this little case study has no specific facts, and I've mentioned a couple of times that in cases around redundancy, the particular facts of the case are going to be very important. But looking from a general perspective, the question often comes up as to whether the fixed term employee can be in a pool of one in these sort of situations, or whether other staff, both permanent and fixed term, will need to be drawn into a pool of selection. And I know that from the university's perspective, it often feels awkward to the idea of pooling permanent employees when a fixed term is expiring in cases of redundancy. So should there be a sort of pooling in these circumstances? And it really depends on whether the fixed term employee can be said to be carrying out the same or similar work to others. If they are, then pooling and use of objective selection criteria is likely to be the correct approach. It's often the case that people have generic job descriptions in universities, so part of the decision-making process around the pooling will be the extent to which this researcher is carrying out standalone work. If they've been dedicated, for example, to a particular research project that's coming to an end, then it seems arguable that they should be treated as a standalone role. if the research project they're involved in is continuing, there is a requirement, and there's just a requirement for fewer researchers, and it's going to be much more difficult to single them out on the basis of the expiry of the fixed term. In that situation, it looks more likely that pooling is going to be required with the others involved. Would you need to pool with people who, other researchers who are on other research projects across the university? Well, I mean, on the face of it, that looks fairly disproportionate. As I say, I think you'd need to look at the work that the particular individual is doing. And if they're dedicated to a particular research project, that might well differentiate them from people carrying out research under other research projects and the skills and knowledge that those people have. Obviously, if there is a pool selection, then it's likely to be unfair to select on the basis of the fixed term status. So the key is to have criteria that will apply to everybody. If the individual's not reached the service requirement for an unfair dismissal claim, currently 2 years, you might want to take a commercial view to dismiss without pooling, though you'll clearly have to think about the cultural values within the institution and any risks that may exist on a case-by-case basis. We'll also need to remember that it will be automatically unfair to dismiss if the employee's asserted rights under the regulations and there's no service requirement there. And we'll also need to remember that under the employment rights, under the employment bill, which is these elements are going to likely come into force in 2026. In cases of redundancy, unfair dismissal will be a day one right and will not be subject to the initial period of employment, which will apply to dismissals which relate to something pertaining to the individual. So we'll need to work towards that in due course, and obviously the detail around all of that is still subject to consultation. Okay, so that's the end of my case study, and hope that was interesting. And I'll now pass you on to Bob, who's going to talk about Harvey and the University of Leicester.
Thanks, Michael, and good morning, everyone. Yes, as Michael says, I'm going to discuss an employment tribunal decision on an unfair dismissal claim as a case study for universities engaging in redundancy exercises. Now, normally, as employment lawyers, we tend to focus on decisions of the Employment Appeal Tribunal and the most senior appellate courts where new law is made. We don't tend to look at individual employment tribunal decisions all that often. And this case was actually brought to our attention by one of our university clients that was keen to understand its potential implications for that university. I think it's quite useful as a practical example of a redundancy situation within a university context that many of you hopefully will be able to relate to. So if we go to the next slide, please. I'm going to talk about the facts of the case in a fair amount of detail. I'll try and sum them up as accurately as I can. Any errors I make are mine alone. So if there is anyone from the University of Leicester, firstly, I apologise for putting you in the spotlight. Secondly, if I do get anything wrong, that's entirely my fault alone. So looking at the details of the case, there were 3 claimants in this case, and they brought claims for unfair dismissal in the employment tribunal against the university following the termination of their employment by reason of redundancy. The claimants were all employed in the university's business school, which is within its College of Social Sciences, Arts and Humanities. 2 of the claimants were associate professors, one was a professor, and the business school comprised of 2 departments and 2 divisions. There was the Department of Economics, Finance and Accounting, the Department of Marketing, Innovation, Strategy and Operations. And there was also the Division of Work and Employment and the Division of Management and Organization. And the reason I'm telling you that is there is some relevance to the way that the business school was set up in the redundancy selection process. So the background to this claim is that in the summer of 2020, the university undertook a strategic review of its activities across the entirety of the university. And as a result, it identified that its business school was losing market share because its student recruitment was not as good as other competing business schools. And the review identified strategic ambitions Firstly, to be a top 25 business school in all areas of activity in the UK and to be competitive at a global level. And secondly, to ensure that future research-led scholarship and learning enabled the university to deliver the skills and knowledge that students would require now and in the future. And I'll just pause there to say that I would expect this kind of strategic review to be familiar to many of you on the call. It's certainly consistent with the situations on which we've been advising over the last, say, 12 to 18 months. As we all know, the sector's under significant pressure from a variety of directions, including regulatory expectations, student expectations as consumers, and all of the various factors that have contributed to the significant financial stresses facing most universities that I'm sure I don't need to recount and you'll all be well familiar with. A recent OFS report, well, the OFS had previously said that it expected 40% of universities to be in financial deficit in the 23-24 financial year. And a recent report has now said that by 25-26, the OFS expects that 72% of universities could be spending more money than they have coming in and may have to use an overdraft or financial reserves, with a total £1.6 billion deficit forecast across the sector. So obviously in that context, there's enormous pressure on universities both to cut all costs, all extraneous costs that they can. And sadly, I think the position that we're seeing is that having exhausted non-staff costs and cuts by voluntary processes, many universities are now having to consider some kind of compulsory redundancy situation. And also pressures to compete as strongly as possible for market share to try and reduce the need for any kind of cuts. So as I say, this strategic review, and it is a few years old now, but I imagine it's one that you'll all be relatively familiar with. So anyway, back to the University of Leicester's position. So having established its strategic ambitions, the business school then gave staff the opportunity in consultation meetings and via a staff questionnaire to input into those ambitions. And the outcome of that process was a decision to move away from certain areas of research which were regarded as not contributing to these key strategic goals. The research areas were critical management studies and political economy. A bit of a mouthful, and that's then referred to in the rest of the judgment on the case as CMSPE. So I'll use that acronym where it's appropriate. So having established that core principle, the dean and the deputy dean of the business school then made two key decisions. Firstly, they decided that it was clear to them from their working knowledge that the research activity of the teaching and research staff in the economics, finance and accounting department aligned with the proposed strategic focus for the business school, and no members within that department were conducting research primarily in the CMSPE area that the university was planning to divest itself from. Secondly, they carried out what they called a screening process to decide whether or not an individual's primary research focus was CMSPE. And that process amounted to reviewing what they called a basket of indicators, including publications, grant applications, self-declared affiliations, and content on the university's own website. And they recorded the outcomes of these reviews in an Excel spreadsheet that didn't appear to apply any particular weighting or scoring, nor did they take any notes of the discussions that led to those decisions. And that spreadsheet over time then became the matrix used in the formal redundancy consultations that flowed from this pre-screening process. And it was updated with the outcomes of consultation, but the original versions were not separately retained. And so by the time we got to the tribunal, it was therefore not possible to see what screening was undertaken initially, nor to understand what had been added or removed. Now, in addition to that, no staff or trade unions were consulted over the screening process that the dean and deputy dean undertook prior to it being utilised. And at the time of the screening, the basket of indicators weren't shared with the staff screened nor with the trade union. When consultation commenced, there was actually an entire internal review process to assess the suitability of the screening indicators that had taken place, but that didn't actually lead to any change in the output for the three claimants. So a total of 16 employees, including the three claimants, were found to focus their research primarily on CMSPE, and those 16 were placed in a pool for redundancy. No further selection process was carried out, and the employees placed within the pool would be made redundant unless through consultation they could convince the university that their primary research focus was not in the CMSPE area. And then from there, the process becomes relatively standard. Consultation meetings were set up, including collective consultation meetings with trade unions, group consultation meetings with staff, and individual consultation meetings with those at risk. 6 new roles with different research focuses were created, but they, to be fair, were not regarded as suitable alternative employments by the university, with the onus being on the employee to satisfy that they could in fact undertake those roles. And essentially the university's position was it would take a significant amount of time to change your area of research focus and be up and running in a way that appropriately contributes to the university's goals. It's not simply a matter of swapping and changing instantly, and they needed people ready to go at the start. And at the end of that process, the 3 claimants were given notice of termination and the right to appeal. They exercised the right to appeal, but ultimately appeals were not successful and they were dismissed and then brought claims. And so if we go to the next slide, please. And the case went to the employment tribunal, and the employment judge concluded that the claimants were unfairly dismissed. Even though there was detailed consultation and appeals, the judge said the process was flawed and the dismissals were not within the range of reasonable responses. Now, amongst the particular findings that the judge made, he said that regarding the decision to exclude the Department of Economics, Finance and Accounting from the selection pool, this appeared to have been reasonable, and he accepted that the university genuinely put its mind to considering which departments or divisions of the business pool should be put at redundancy. However, where the university fell into error was the pre-selection then carried out. And the judge said that effectively selected whether the individual staff would be made redundant, since it made clear that unless through consultation individuals were able to convince the university their research focus lay within its future areas of research, i.e. not CMSPE, then they'd be made redundant. As such, the judge considered that the screening exercise was effectively a selection process. And he said that a reasonable employer would have viewed it as such and crucially, consulted about it in advance of its use. The judge also made some critical comments about the nature of the record keeping and the lack of evidence about scoring or weighting carried out when the dean and the deputy dean came to the conclusions they did about who was going to be in the pool. The deputy dean's evidence as to why only 16 staff in the relevant department were put at risk was that it would have caused unnecessary stress to staff who were not ultimately made redundant. And that is actually a factor that I've heard raised both within the HE sector and outside of it by employers wanting to carry out a redundancy selection process, but minimize levels of stress to staff that ultimately may not end up being selected. But in this case, the judge said that's not an acceptable reason for undertaking a process in this way. And a reasonable employer would have both consulted on the selection process to be adopted and would then have carried out the selection after the consultation had taken place with all staff who were to be scored as part of the process. So ultimately, the process was flawed in there failing to be appropriate consultation on the proposed method of selection prior to it being used, and in the decision to exclude some business school employees in the pool in order to avoid unnecessary distress. So if we go to the next slide, please. What lessons are there to be learned from the case? What pitfalls are, what ways can we avoid pitfalls? I've set out on the slide what are hopefully some fairly obvious points. So identify appropriate pools, identify selection criteria, and I should add to that, and undertake a process to apply the selection criteria fairly. Where unions are involved, as they almost always will be in a university context, you no doubt will all be familiar with the Williams and Compare Maxim judgment that sets out the process and the key points to be applied, but you will need to consult on the pools and the criteria with trade unions, and then consult on the criteria with the individuals before any decisions are made, and ensure that a fair and reasonable selection process is adopted. And I think the one key point that I would take out from this decision, and of course it is actually just a relatively straightforward redundancy unfair dismissal case in the greater scheme of things, but what it is flags to us, it doesn't generate any new law, but what it flags to us working in the sector is that in cases where selection from a pool is required, you will need to be very cautious of having a situation where effectively you have a pool of employees that is smaller than the total number of employees performing the same or similar roles. And all of the employees in that pool are likely to be dismissed unless suitable alternative employment can be identified. And if you see that situation, then you need to be aware that you might be at risk of falling into the same error that unfortunately the dean and the deputy dean at Leicester fell into here, where their pre-screening exercise was actually a selection process of who was going to be made redundant, subject only to alternative employment. And that's where the mistake was made here. I've had conversations with various clients about needs to simply reduce staff-related costs in the current climate, and how to achieve a situation where you're not effectively putting an entire category of academic staff at risk across the entire university on the one extreme, and not creating a pool that is essentially those to be dismissed at the other extreme. And I think the other good lesson from the Leicester case is that it is reasonable, or it can be reasonable, to properly apply your minds to reducing or targeting key areas. And so other examples that I've seen include things like where a strategic review identifies the importance of externally funded research, for instance. You might want to look at ways in which you have a pre-screening assessment of departments or schools or faculties within the university that meet, say, minimum thresholds of external research funding, or you might want to use other methods of assessing overall contribution. And in some ways, the HE sector is fortunate in that it is so heavily assessed. There had to be some benefit to it. So TEF scores, REF scores, National Student Survey outcomes, there is actually quite a lot of data, and there are a lot of data points available to assess overall contribution of departments or faculties to key strategic goals of the university. So I think there are quite good tools potentially available to you to help you, first of all, identify what it is that you're seeking to achieve, and then narrowing the scope of your potential pool to parts of the university, putting it as broadly as possible, that can be demonstrated not to be contributing as well as others towards that goal, whatever it might be. One final point I'll make is that the selection from a pool scenario is not the same situation as that where there is a reorganization where all roles are being made redundant and new roles are being created. And in that situation, I'll just quote the Employment Appeal Tribunal in the case of Morgan and Welsh Rugby, the employer's decision must of necessity be forward-looking and is likely to centre upon assessment of the ability of the individual to perform in the new role, such as by an interview process. So it's worth bearing in mind that there are situations where the more constrained selection and consultation process that happens when selecting a pool won't necessarily apply. Um, so that's everything I wanted to say about our slightly more in-depth case study. I can see we've got some questions in the Q&A box. Please do feel free to ask us anything else and add to the list of the things we've got to go through. Michael, it looks like the first one is a fixed term contract question. So do you want to pick that up?
Sure. Sure. So the first one, excuse me, squinting at the screen. The first question is, what happens if fixed term contract is not renewed for the current post holder, but the employer re-advertises the same or similar role for another fixed term? Would this be deemed discriminatory? Well, I think that the greater risk, or perhaps the one I'd highlight first, would be that bringing a fixed term to an end and then re-advertising the role or a very similar role, uh, there's a risk of unfair dismissal there because the end of the fixed term will count as a dismissal at law. And obviously, if the role was continuing, you'd need to have a good, fair reason for that dismissal rather than renewing or offering the new role to the individual. Would it be deemed discriminatory? Well, I think that would depend upon the reasons why this individual was not given the new role or the opportunity to apply for the new role. So I think it's discriminatory issues are obviously there, but it's more a risk around unfairness if the individual has the requisite period of employment. Um, Anything to add, Bob, or shall I go on to the next
No,
one?
I think yeah, no, I agree, and
Yeah.
I don't think I have anything to add to that.
The next one is uh, in a redundancy situation, is it reasonable to give priority to find alternative employment to permanent staff at risk of redundancy, particularly if a fixed term employee has less than 2 years service? Well, I think the fixed term regulations certainly single out the fact that fixed term and permanent employees should be given the same opportunities around alternative employment. So I think it probably would be problematical to do that. Obviously, if the fixed term employee is less than 2 years service, they may not have access to unfair dismissal rights. So there may be a commercial decision to be made there. Um, and lying behind all of that, I suppose, that when someone interviews or when someone is considered for alternative employment, uh, someone who's a permanent employee, there may be objective factors around that permanent employment and the role they're undertaking, which would give them a better chance of getting into that role than someone on a traditional fixed term, particularly if it was a short-term fixed term contract. But on the face of it, fixed term employees and permanent employees should be treated the same in terms of access to alternative employment in a redundancy situation. Anything from you on that one, Bob? Or
Well, I suppose it's likely to be less favourable treatment unless objectively justified. So there is always the scope for objective justification.
yes,
But as you said in the main body of your presentation, I think that in many situations, that objective justification is going to be quite difficult. And certainly if it's just a case of a general feeling that it's unfair on the permanent staff, that they lose their permanent role because someone on a fixed term contract meets the selection criteria better than they do, I think that's unlikely in itself to amount to an objective justification. There might be some fact-specific situations, as you were saying, relating to funding or whatever it might be, where you're better able to do it. But yeah, otherwise, I think it would be quite a risk. I think you're doing most of the heavy lifting here, Michael, because we've got another fixed term question.
oh right,
Uh,
okay.
um, it says if we were to keep someone on a fixed term contract due to temporary funding after 4 years service, how far would we need to justify this? Or would we need to make them permanent as the funding wouldn't be seen as temporary? Um, I
Yeah.
mean, I think that's actually a relatively common situation.
Mm.
Um, and uh, I've certainly seen plenty of examples where uh, fixed term contracts in excess of 4 years, which are dependent on a specific external funding source, are used in the sector. And in the organizations who are doing that, they are necessarily relying on an objective justification. I don't know about you, Michael. I'm not aware of uh, certainly any appellate case law that where that kind of objective justification argument is tested. But I think that it is an area where you can make a good arguable case for objective justification,
Yeah.
where you definitely do have a fixed period during which the employee services are required, and it's longer than 4 years, and at the end of it, because of the funding dries up or just comes to its natural end, the role isn't needed anymore. Um,
Yeah. I think it's I think there's some good arguments for justification of the continued use of fixed term, meaning that the employee wouldn't be deemed as permanent in
yeah,
situations where, at the expiry of one fixed term, there's a careful consideration of what the funding situation is. And if the funding continues to be temporary, um, that there is a further fixed term. And I think that could be, in theory, quite a good argument for justification.
yeah,
Um, there has been case law in the past. I mean, Aberdeen, many years ago, there was a case, Ball versus Aberdeen, where someone, a researcher who was on successive fixed terms, was deemed to be permanent. And I think that the unions sort of, I've certainly seen letters from the unions citing that case as the reasons why particular fixed term employees should be treated as permanent. But the facts of the Ball case are quite specific in the sense that in that case, and it's several years ago now, many years ago, but in that case, the fixed term was employed without thought on an automatic basis several times. And in that situation, there's clearly going to be a risk for a university, quite a high risk that someone might be deemed as permanent. But at the converse would be situations where there is a careful consideration at the expiry of a fixed term about the continued use of fixed term contracts and whether that is justified in particular circumstances. And temporary funding may well be one which would continue to justify that. So it is fact specific, but you know, I wouldn't, as long as it's looked at carefully and you draw a proportionate decision, um, the case that you wouldn't be lost in those sort of situations, I don't think.
yeah. We've actually seen quite a few HEIs more recently actively moving away from using fixed term contracts with externally funded research and simply using a permanent employment contract for the relevant research staff, but recording within that contract that their employment is dependent on the external funding.
Mm.
And they're doing that largely to remove the administrative burden of successively renewing fixed term contracts um, and simply approaching it on the basis that if we get after a 7-year period, to take a random number, a loss of the funding on which this person's job depends, then we will have a redundancy situation, and then we'll need to consult
Mm.
about making that employee redundant because the funding for their job has disappeared. So, some clients and other HEIs are actually trying to move away from them because they don't think they're helpful in that context.
Yeah.
Um, Right, the next question is, does an organization need to consult with the recognized trade unions first for the required length of time prior to commencing any individual consultation meetings, or can both happen concurrently at the same time? We have received conflicting advice from employment lawyers. Thank you. Yeah, there's a few things to say about that. So, um, first of all, bear in mind that what Section 188 of Tolkien actually says is that you are required to commence consultation either 30 or 45 days before the first dismissals take effect. There is no obligation to consult for a particular period. It's about when the start and the end uh, relate to each other. Obviously, you have a duty when collectively consulting to do so with a view to reaching agreement. You're not obliged to reach agreement, and if you reasonably exhaust the issues that you're at odds with your trade union, you can come to a point at which you can say, okay, we've done everything we can, we've tried to reach agreement, we've genuinely negotiated, and now we've got these outstanding points on which we're not going to reach agreement. So I would say that there is no absolute bar to commencing individual consultation within that period. However, the earlier you start, the harder it's going to be for you to justify a position that you have complied with your duty to consult in good faith about the things that you're required to consult about, such as selection pools and selection criteria. So if you start your collective consultation asking the unions to agree to the selection criteria and scoring you're proposing, for instance, and at the same time you're applying those selection criteria and beginning individual consultation, you're highly likely to find yourself on the receiving end of claims under Tolkien. On the other hand, if you have undertaken a reasonable consultation period, undertaken a reasonable consultation and got to a point where the time period since the start of the consultation is less than 30 or 45 days, but either you've reached agreement or it's clear that you're not going to, the risks of starting might be relatively low. And of course, at the pace at which individual consultation tends to take place in the sector, is probably going to mean that you're unlikely to have even given notice to the employees to dismiss on redundancy grounds before the 30 or 45-day period expires, much less the notice period expiring and the termination actually taking effect. So I'm not sure why you would have got conflicting advice from different solicitors, but I certainly find that a lot of the time it's the way the question is asked that leads to a different answer. But if they're literally just giving you flatly contradicting advice, then I don't know, maybe you need to speak to us. The one other thing I would like to say about that, though, and this is kind of one of my top tips, but I do tend to encourage HR teams that I work with to think of consultation, collective consultation, not just as an obligation, but as an opportunity. Because if you actually do manage to secure union agreement to the individual process of selection and pooling that you intend to apply, that quite strongly inoculates you against unfair dismissal claims from individuals on the basis that those elements of the process are unfair because you've got union agreement to them, which is quite a substantial support. So there's a real opportunity there, I think. Now, obviously, if your local or regional branch of the UCU or other relevant union is flatly determined not to agree any criteria at all, perhaps it's not the opportunity that it might otherwise be. But yeah, there's definitely an argument to be made, not just to regard it as an obligation that you have to trudge through, but something to take advantage of where you've got a reasonable person to speak to on the other side. Got a couple more. I've got a few more actually. If we had 4 research administrators in the same department and their full-time contract was ending, FTC fixed-term contract was ending, as there is no more funding to extend, would we need to put them in a pool, or would we simply be that we pay them all a redundancy payment? I think you've kind of answered that, haven't you, Michael? The short answer is it depends. Did you want to say something more though?
No, I suppose that the thing that leaps out from the question is that there's no more funding to extend, and I guess if that's the research project coming to an end, those individuals would all be at risk of redundancy, wouldn't they? And
Yeah.
there would then be the question of alternative employment, etc.
Yeah. I mean,
If
if
it's
there's
just the fixed terms coming to an end, but there are other permanent employees who are continuing with that research project or a very similar one, in those circumstances, you might need to look at pooling the people's fixed term coming to an end with the others because you've got a reduced requirement for the number of researchers on that particular type of research.
yeah,
It is quite fact dependent.
yeah. Um, from a pool From a pool, are people applying for the smaller number of remaining jobs, or are we selecting for who is to be made redundant? I'm not sure I quite understand that question. Smaller number of remaining jobs, or okay. Well, those are both. You can have a situation where you are, if you are simply reducing the number of people doing a number of jobs, then um, you would normally apply a pool, apply selection criteria, and select those who are going to be made redundant. If you want people to be applying for a smaller number of remaining jobs, that sort of application process is normally appropriate to a situation when you are actually creating new and different jobs to those that are disappearing. So it depends on the specific situation that you find yourself in.
Mm.
Michael, is
I
anything
think
you want to
we,
add to that?
no, I don't think so. I don't think so. And we're right now at the end of our time. Um, I think at
Yes.
30, aren't we?
There's one question we haven't got to. If the person who has asked it would like us to discuss it with them, please do get in touch directly. If you move on to the next slide, please, our contact details are there. But otherwise, thank you very much for joining us today. And if you have time to give us some feedback, that's always very welcome.
Thank you very much for attending.
Thank you. Goodbye.